Okay, Rob, we're here today to talk about your chapters in the Politics of Common Law. You wrote the two on criminal and civil justice chapters towards the end of the book, 15 and 16. And I just really wanted to ask you, what do you think the big idea of yours in these chapters? Because they're kind of, some people say, well, a bit, civil process, criminal process is a bit dull, but these aren't dull. How do you think you approach these matters?
Well, I think that for both of the chapters I thought, well, how can I make this different? So what I did with the civil chapter particularly was to, what I thought was look at the process and then think what I thought were the most interesting parts of that process. So, and then obviously then hone in on them and spend some time talking about them, and obviously hopefully making sure that they illustrated what I felt were key issues within the civil process. So things like access to justice, things like equality, and concern about access to services, all those things that people don't tend to talk about in the context of civil process, but certainly do talk about when they're talking about civil justice.
Yes.
Then with the criminal chapter, what I tended to focus on was look at the idea of this system and the fact that there's supposed to be a criminal justice system, but obviously there are problems with that system. And one thing I make quite clear in the chapter is the fact that there is a lack of conversation, if you like, between each of the different agencies, and a lack of joined up thinking, which of course does hamper, I think, the administration of justice, but also try to understand some of the concerns that people have when they are on the other side of the criminal justice process.
Yeah. No, I think just because one of the bits that I wrote, I guess one of the link-ins there between your bits and my bits was certainly around themes like access to justice and also equality. I mean, the big due process arguments that we make in the book seem to me to link quite nicely with your arguments about how, particularly the sections in that civil justice chapter where you're talking about the way the civil justice system, I'm probably misquoting you, so please put me right, kind of almost acts as a way of distributing resources, if you like, or solving issues around the distribution of resources.
Yes, I mean, obviously what I choose to do is to look at the general ideas concerning access to justice, because people need to understand how the system operates and what the key ideas are, and how there's been certainly something of a seismic shift when it comes to things like alternative dispute resolution. And of course the key about alternative dispute resolution is the concern, the growing concern that's certainly emerging, which is that this is not alternate dispute resolution, this is the form of dispute resolution. Which in itself, of course, tends to promote an idea that there's a lack of access to justice because people are being diverted away from the courts. Now, most people think that's a good thing. I'm certainly not arguing it's a bad thing, but I think that the court at some stage is there to resolve people's disputes. I think that why we tend to sort of say to people, okay, you shouldn't be using this form of dispute resolution because you should be using other forms. What we're tending to say to people is actually, you have no access to justice. You shouldn't be using the courts. They're too expensive for you.
Exactly. I mean, I think these are the issues in detail, aren't there? I don't think there's I suppose there's that question of supplement, particularly in relation to ADR and, let's call it, for want of a better word, the formal court system. And I'm not sure that most people would say, look, ADR's got no role in civil justice. That's going too far. It's that, well, balance, again, is a bit of an overused metaphor, but do you think that kind of idea of integration, or again, systems talking to each other in a fair or an equal way, would you say that that's a kind of a guiding theme?
I think it is a guiding theme. If everybody, certainly from my perspective, I don't certainly argue that ADR shouldn't be used, because there are certain, obviously, areas of law where ADR is absolutely critical, and certainly areas such as family law, you would argue the mediation was pivotal. However, sometimes people just want to go to court, and what I think became clear is that the literature promotes ADR, but it seems to do it at the expense of court. I think that's what I'm concerned about, is that sometimes people want the court to resolve the dispute. They can be directed away from it through other forms of ADR, but there will be some people who still want to go to court. And I take the view that actually those people should have access to those
absolutely.
courts.
I mean, I think I'm trying to remember I mean, there's a huge literature on ADR, and one of the examples that always struck me as a good one, as the kind of dispute that has to go to court, in other words, it would be used as an ADR, is I think it's the desegregation of the schools in the south of America, south of the United States, where there would, given the power imbalances, given what's at stake in that piece of litigation, I suppose, there would be no point saying, oh, this can be mediated, or this can be dealt with you need the power of the court. some
Yes.
disputes.
I mean, that's the point. I mean, some disputes do need it. I mean, in a less sort of pivotal way, I suppose, what's happening, I think, and this is certainly the trend, is that because everybody's focusing all their attention on ADR, it's become something of a sort of cheap fix for some underlying problems in the system, which is that, you know, courts are expensive, governments don't want to fund courts, and so what's happening is they're diverting people out of the courts and saying, don't go to court because it's going to cost you so much money. That deters people from going to court, and that in itself, of course, denies people access to justice.
I think that's an interesting point, and I'm not sure that we ever picked up on perhaps this theme in the book in the way we should have done, but the whole problem around legal aid.
Yes.
I guess, you know, to relate to what we're talking about, within civil justice would, I suppose, simply be another way in which that theme is playing itself out.
Yes, I mean, obviously in the chapter I do talk about Steele and Morris and the
Right.
Coleman libel case,
Yeah.
and of course that to me demonstrates the idea that there should be some equality of arms, and of course in that particular case there wasn't. And I mean, certainly concerns surrounding this are that because if you don't have any money, how do you protect yourself? How do you defend yourself? Or indeed, how do you bring cases against people who perhaps have injured you in some way? Now, we've developed a whole world of sort of systems where we expect people to engage in pre-action protocols, we expect people to engage in this sort of ADR system, but if people ultimately want to go to court, I do think there is a place for that.
Absolutely,
But what's happened is there's developed this rhetoric which is anti-court.
Yes.
Because people are frightened of court, the big bad court which is going to cost you lots of money, when there are ways in which you can limit what is going to happen in court, because you can say to people, okay, for this fixed fee, you can have access to justice.
Yes,
and I think that's a possibility, but I think it's ignored in this anti-litigation rhetoric.
No, absolutely, yes, and I think
about.
that, again, it so clearly feeds in as well into kind of austerity agendas, and there's a massive kind of political set of issues, I guess, around here as well. We've talked quite a bit about civil justice so far. I'm wondering if we could, I suppose one of the themes, perhaps the bridging themes, obviously civil and criminal justice, you can't blur them, their systems doing very different things. But just as in a sense, one of the bridging concerns might be at that level of, I think you said a little bit earlier on, a system needs to talk to each other. And perhaps one of the themes in the criminal justice chapter is, again, that is not happening, the systemic dysfunction, if you like.
Yes, I mean, obviously we understand the separation of powers and we're very clear as to how that operates, but what becomes clear is that where there is a political will to drive a particular agenda through, then of course there are certain parts of the system which aren't prepared to buy into that. And what I think I certainly do emphasise in the chapter is this idea that you may have the police force, for example, they have a particular role to play, but they also find themselves subject to extreme criticism, and some of it is absolutely right, but other times people say, well, it's not quite right, because again, it's to do with resourcing and the political will in order to fund it. But I think tied up with that is the fact that you might have a court system which is delivering very different messages. And that in itself, because they don't speak to each other, I suppose there's always the risk that if they speak too much to each other, there's going to be this sense of collusion between them. And I'm very keen to keep those separate. But I don't think independence is just about where people are. I think it's also about a state of mind. And as long as the particular aspect of the process is robust enough to say this is what we do, then I don't have any problem with that. But I do think there's a problem when they're blindly ignoring each other. And so, you know, courts are being told to send people to prison. Prisons are saying we've got no more space. I mean, it seems odd that the courts would then simply continue to reinforce the point that people should be sent to prison. That doesn't make sense.
No, I think that the other thing that stood out for me, and I think that this reflects an on-running problem in the British criminal justice system. Obviously, you know, you've got that very striking picture that opens the chapter, and there's concerns with policing terrorism, and we all know what's gone wrong with that. We all know about Stephen Lawrence and all the miscarriages of justice things. I mean, that seems to me, again, another guiding thread throughout the criminal justice chapter are those very high-profile examples of things going dreadfully, dreadfully wrong.
Yes, I mean, obviously, because I wanted to demonstrate what the tragedies can be, and I talk about hostages and fortunes, and I'm very clear on the idea that obviously when you don't need the system to work properly until it affects you, and that's what some people obviously do consider to be important. But I do think that some of those key cases are significant because they obviously bring it alive, and if we're it's all feeding into this idea of imagination and trying to help people to understand, well, rather than just looking at a set of rules, what happens in practice and how do you bring it alive? And I think obviously those cases help that.
Yes. No, I did want to ask you about the titles of these chapters, Imagining Criminal Justice, Imagining Civil Justice, because you tend to think of the world of law as kind of dry as dust. Procedural law is often even dustier than the most dusty form of law. Whereas all of a sudden in your chapters this word imagination appears.
Right.
And is that seems to me again kind of authentic to what you're doing here, both at the level of the writing, how you write about such complicated systems, but also in a sense that I guess we want to engage the reader. We want the readers in a sense to work their own imagination.
I mean, I say at the beginning of the civil justice chapter that obviously, quoting Einstein, that imagination is more important than knowledge. And the idea of that is just simply that if we ask the reader to imagine, and I give some examples in the chapters, that if people imagine particular scenarios where they then can sort of say, well, look, how will the process affect me if I were in that situation? And I think that's what I was trying to get at, because it then allowed me, as it was a vehicle, to allow me to demonstrate, well, look, these are the problems with the system, both in a civil sense. So when I talk about sort of distribution of land or access to medical resources, these are things that some people may be really particularly interested in.
Yes.
And the same is true of criminal process. I mean, people may not necessarily be interested in it until it affects them directly, or they've got a family member or a friend who's obviously had some interaction with the police, with the courts, with the prisons, and that's when those issues become particularly important.
No, I think you're right, and I think one of the difficulties, perhaps, because I mean, there's lots of accounts of English legal system or legal method or what have you. I think one of the things that you were doing in your way, Wayne, and I were doing is there is a kind of, and this might be an element of self-aggrandisation, but I think it's there in the book, is there is in a sense to say, well, look, one needs a kind of, I'm not sure if vision is the right word, but one needs to follow a kind of a thread, a set of themes when one is thinking about a legal system, which is necessarily difficult to grasp, disembodied. What's it doing? Is it just this massive detail? And in the end, it's a system attempting to resolve, for want of a better word, real-life problems. Okay, I guess there's this sense then, and I think as writers of this book, we came across this idea that a lot of books in this area tend to be a little dry, and one of the ways of perhaps attempting to write about it in a different way, and hopefully a more interesting way, is exactly to go back to exactly what you're saying, is to try and make it important for the reader by saying, well, this may seem disembodied and boring and abstract, but imagine that you are in this situation. Imagine that you have a civil problem or a criminal problem. Then it becomes a very real thing for that person.
Yes, and I mean, I come back to this point about imagination is more important than knowledge. I mean, ultimately, knowledge is about the rules. It's about how the system operates. And, we expect people to understand that. But at the same time, if you don't have imagination, you can't understand how the system will work in practice.
Exactly.
And, of course, unless you've actually experienced it, then you have to use your imagination in order to do that.
I think that's a great point. And the thing, again, that was, I suppose, that runs through this book, and it was strange being three people trying to write one book. In a sense, we all did our bits and then we tried to make them fit together. But the themes that run through it, to me, are precisely about the principles, if you like, or the values, possibly, that inform the different things that you're talking about, Wayne's talking about, I'm talking about, which I kind of bracket in the idea of due process as a spirit. More than that, a set of principles, but a spirit that informs the law, informs the case law, it informs the way institutions operate, or it should do. Whether or not it does is that issue of imagination, perhaps, if one had to push that a little bit, perhaps the imagination that you're invoking and the book in general is invoking is that question of, well, what should law do? Even if it doesn't do it, how should legal procedures work? What values should inform them? What principles should inform them? Which to me goes back to I suppose a due process argument or a human rights argument. I'm not sure you would necessarily agree with me on the due process human rights arguments, but I think I'd be right in saying we share that kind of, focus on due process in different ways.
Yes, I mean, obviously concerns I raise in the chapters, and certainly the criminal chapter, is this idea that politically what happens is that if there is any form of hysteria, and usually obviously fueled by the media as well as people's genuine concern, is that what tends to happen is we revert to a much more crime control sort of arrangement. And of course the due process is what we need to remind people is what we should attempt to exemplify. there are issues, as you say,
Yeah.
with the due process model, and it may be that it's not foolproof, but it's certainly better than the rest.
Yes.
And I think that's what we probably do agree on.
I think that would be the perfect kind of conclusion to our discussion, that